This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together. Good morning, everybody, and welcome to class number 6 of our spring virtual HOA Condo Academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, and Tempe. My name is Beth Mulcahy, and I'm the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I have enjoyed representing HOAs and condos for the past 24 and a half years, and my firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have for many years. So I hope that the classes that we've provided to you so far, the first 6 classes in 2021, have been helpful to you. This class is designed only to answer your questions. So any questions that you may have regarding your association, it's an opportunity for you to have an HOA or condo lawyer answer those questions for free today. Okay, so let's start out with a little poll. I always like to see who's here today, which cities are represented. So the first question is, in which city do you reside? So the options are Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, or Surprise. So if you're living in one of those cities right now, or your HOA is in one of those cities, or maybe you're back in the cool Midwest watching live this virtual seminar, just let us know where your property in Arizona is located. So it really helps us to know who's participating today and which cities really need to have more classes like this. Basically, typically we see the cities that have the largest number of people coming to these classes, we encourage them to have more classes. So it looks like we have nobody from Avondale today, 5 people or 9% from Chandler, 1 person from Glendale, 1 person from Goodyear, 6 people from Mesa, 3 people from Peoria, 14 people from Scottsdale, good job, Bruce, and 0 people from Surprise, 2 people from Tempe, and 21 who have listed other. So welcome everybody today. It's great to see all these different cities represented. And one of the benefits of teaching these classes virtually is it allows us to collaborate with a large number of cities in the Valley to provide free education for all of you. And just based upon the feedback that we've received on the classes and the number of views that we see on the classes after the classes are over, we've determined that these classes are beneficial to your residents and provide valuable information for you. And people are tuning in before and during and after the classes. Okay, so let's get a start with the first topic we're going to talk about today. I just want to give you a quick legislative update because now is the time of the year that the legislature is winding down their session. As you probably know from tuning into prior classes, there have been 4 bills that have been signed by our governor so far that will go into law once the legislative session ends. But this has just been a really weird legislative session. I don't know if it's related to COVID or the unrest in our country or just a number of different things. But this is an especially long session. I can't remember. I've been following the legislature for HOAs since 1996, and I cannot remember one that has gone this long into June already. So this is a long legislative session. Basically, what's going on is the budget needs to be passed so that the association, so that the state can, fund things. And the legislature is currently fighting about what should be included in the budget and what shouldn't be included. And that the delay and the reason why the legislature hasn't closed for 2021 is directly related to the fact that the budget hasn't been approved yet. And they have to approve this by the July 1st deadline. So I think in a little bit of a political move, this past week, the governor has called for a special session to address the wildfires that are occurring around Arizona. And I think that's probably an effort to get everybody back to the Capitol, get back to work, because that July 1st deadline is looming, and also an attempt to put into place measures to help the many people that are being affected by the tragic wildfires. So we'll just have to wait and see. Probably by the time we have our next class in July, our next Neighborhood Services Virtual HOA Academy class, we'll have more information for you. It's really doubtful, in my opinion, that there'll be any more bills passed this year pertaining to associations. So I think these will probably be the final bills, but you'll have to tune in July to be sure. So the 4 bills that have passed this year, one bill is Senate Bill 1377, and we're going to be sharing in the chat our legislative summary so that you can have it at your fingertips, and also on Zoom and also on Facebook. So the first bill talks about liability. It's Senate Bill 1377. Again, all 4 of these bills have passed. This basically just makes it difficult or basically impossible to sue an association, HOA, condo, or other businesses for pandemic-related lawsuits, so long as the association was acting in good faith. So this is really a great bill for associations this year in terms that it will limit our liability for any COVID issues as long as we are acting in good faith. The next bill talks about mask mandates, business exception. Some of this is kind of becoming moot because the legislature is just going on and on and on and not convening for the session. But basically, this bill is House Bill 2770. It says no matter any other law that's out there, a business in this state is not required to enforce its premises on its premises a mask mandate that is established by the state, city, town, or county, or other jurisdiction of the state. So again, like I said, this is kind of moot because, most states now have no longer in place mask mandates. But again, it's just a pandemic-related bill. The next one is Senate Bill 1722. This one talks about political signs. And basically, it just extends the time a political sign can be left up on a person's property until 15 days after the general election, or if the sign is for a candidate in a primary election who does not advance to the general election 15 days after the primary election. So basically, it just took the time period that you can keep political signs on your property from 3 days to 15 days. And that's probably the largest development. So House Bill 2170, Garnishment Bill. This allows association attorneys to include their legal fees for the garnishment in a garnishment action if those fees are allowed by the judgment or contract. And so this is a great bill for associations. Previously, if we filed a garnishment action, it wasn't clear as to whether or not we were entitled to get our legal fees for filing the garnishment action. So now this has been established and it's clear. So that's a good thing if we're pursuing owners for non-payment of assessments by garnishing their paycheck or their wages or their bank account, or if they have a tenant that's renting in their property, we can garnish their rent if we have a judgment against them for unpaid assessments or unpaid fines, etc. So those are the 4 bills. No sweeping changes. They apply to all condominiums and planned communities in Arizona. Honestly, the only one that I really think is going to come into play at all for associations directly would be keeping the political signs up a little bit longer after these bills become effective. Probably it will be, in August at this point, maybe even September, depending on how long the session goes. And then, of course, for garnishments, having the attorney's fees is a huge perk. It will make it easier for us to garnish, and will stop the vicious cycle of owners not paying. Okay, water safety. Just a quick reminder, it's so hot out. People really need to be thinking about, everybody's thinking about how can we stay cool this summer, but just want to take a moment to remind you and your associations of the importance of never taking your eyes off of children while at the pool. Thank you to the City of Tempe government and Tempe Fire Medical Rescue Department for providing us with important water safety reminders as the temperatures in the valley continue to heat up. We'll be sharing the link to their recent publication of summer safety and a recap of the ABCs of water safety. And we're going to be sharing that with you on the screen right now. It's just an excellent publication. And we hope that you'll share it with your owners in your community so that we can keep people safe this summer as they're using water. We're going to be starting our questions now. I'm just going to scroll to the bottom. It looks like we have about 26 questions right now, which is just the perfect amount of questions. And how we work the questions is I don't read the person's name who submitted it, and I just read the question and then I just answer it right away. So it's kind of like test the attorney, see if she knows the answers. So the first question is, this was a First Friday question that apparently by mistake wasn't answered when we had our First Friday a couple of weeks ago. So the board wants to make changes or improvements to landscaping in the common area in front of 5 units. Can they do this without homeowner approval? A landscape reserve fund was created and continues to be funded. Some board members are quoting the SCCOA guidelines, stating that anything affecting the common areas must be approved by a majority of owners. I told her their HOA follows their documents and state statutes. Does the board have to consider these rules when deciding this issue? Okay, this is kind of a tough question for me to answer because I don't have the documents for this association. But what I would suggest here is really anytime you're going to make changes or improvements to landscaping on common areas, you definitely should be thinking about getting buy-in from your owners, whether you need to have a vote or not. What I would recommend is that you have your legal counsel review your association's documents and the SCCOA rules to make a determination as to whether or not you need to have homeowner approval. In my experience, anytime you're changing, the use or changing the type of landscaping that you're having on common areas, if it's going to be a significant change, like let's say you're going from grass to desert landscaping, I really do think that it's something that you should be, at a minimum, talking with your owners about at an open meeting. I've been to some meetings where they have a whole slideshow presentation about how it's going to look. The grass is the before picture, and then the desert landscaping is the after picture. Whether or not you have to have homeowner approval, it really depends on the facts of each circumstance. So if I were looking at this issue, I would want to know what changes you're going to make, changes or improvements. Is it similar to what you have there right now? Is it totally different? How extensive is it going to be? And then I would look at your CC&Rs for your association. And I think the CC&Rs will give you the answer on that. It just depends, really. One of the things to think about is, do you need to have a special assessment to pay for this? And maybe that requires a vote of membership, or you can be using, reserve funds. And it appears in this case, you have a landscape reserve fund. So you may be able to fund it with that. So I would look at it from the totality of the circumstances. I would determine how large of a change there's going to be, what type of change there's going to be, what do the CC&Rs for the association say, what do the rules say for SCCOA, although the rules are never going to trump typically the CC&Rs. And then also think about buy-in from homeowners. Even if you don't have to get homeowner approval, are people going to be really fired up about this and mad? And then you may need to have a town hall meeting to discuss it, to make things, clearer in terms of what you're going to do and why the association's doing it. So short answer is I can't give you the answer whether the board has to consider the SCCOA rules, but typically the CC&Rs do trump the rules in an association. So I would be checking for your CC&Rs to see what they say about this. Okay, next question, number 2. How do we go about legally revising the name of our association? It's been recorded in various versions over the years. We would like all of our legal documentation to be amended to the same name. Okay, so great question. So if your association, typically the documents that pertain to your association are going to be the plat map, the CC&Rs, the articles of incorporation, the bylaws, and the rules for your association. But really the naming document is going to be the articles of incorporation. So, what you should do, in my opinion, is go check the articles of incorporation to see what the name is that's listed. I don't know if that is the version that you want or you don't want, but that document is the most important document for your naming. Okay, that's the corporate name of your association. And if you want to bring those other documents into compliance with that document, then you just need to amend them. So typically the plat and the CC&Rs need a vote of the membership to be amended. The rules typically can be amended by the board. The bylaws, it depends. More often than not, the homeowners will need to amend it. So if I were in your situation, what I would do is go to the articles of incorporation, see what the name is. Hopefully it's the name that you want to use for all of your documents. If it's not, then you're going to need to follow the procedure to amend your articles and then amend all the other documents that have the wrong name in it. And some of those documents will need the homeowner's, name or the homeowner's approval to approve the new name. And you need to follow that. Now, in some circumstances, I've seen associations use like a DBA So they go to the Secretary of State's office and they create a DBA for their association. That may be an option, but truthfully, that really kind of mixes things up with the assessor's office, with the realtors who are trying to sell in your association. So we think the correct and proper procedure to do that is going to be to do actual amendments to your documents. Okay, next question. Our condo association of 39 units has several no soliciting signs posted at the entrances to our 3 courtyards. Yet solicitors, religious, political, commercial, charities still knock on our doors. What other preemptive actions can the board take to ensure solicitors follow the rules? Well, a couple things. I don't know if you have like any security measures in place, like a security gate or fencing around your community. I'm guessing you don't. And so these persons are able just to freely enter the association. My recommendation would be contact your precinct of your local police department and ask them, what are some of our options? If we call the police, if somebody enters and is trespassing, will the police enforce it? Sometimes they will if they're not too busy. That would be one suggestion. You may want to install cameras and let people know they're entering the association that you're being monitored, and that there's videotape evidence of any illegal activity that's going on our property, including trespassing. Those would be good suggestions. Obviously you could approach the solicitor, somebody on the board or the management company if they're there at the same time, and politely ask them to leave, or get their card from whatever organization they're with, and then contact the higher ups at that organization if it's like a local organization. I think those are all some good solutions to you. But again, it's hard unless you have a gate and that 24-hour guard or fencing around your association. It's hard to monitor this on a 24/7 basis. So start out by reaching out to your police department, see what they say, and then go from there. Okay, next question, number 4. May a condominium sub-association use a duplicate of the HOPA documentation, certificate of residency, used by the master association planned community, or must they use a document specific to the sub-association? Okay, that's a really good question. So let's see. So the sub-associations, there's a master association that has their own CC&Rs, and now you have a sub-association within the master association. And can they just copy the master association documents? Well, that's a good question. I mean, you can. Most sub-association documents already say that they're subject to the master association documents, which means that they have to comply with them. Of course, you can use a duplicate of the documents and, have your own architectural committee if you want for your subcommittee or for your sub-association. So I think that's fine. But usually the sub-association has different amenities and different needs from the master association. So you usually have some additional provisions that apply just to your sub-association. So keep that in mind. You may want to fine tune the master association documents to make it, more compatible with your sub-association. But honestly, I really don't have any trouble with you doing that if you want to. And this person made a really nice comment. They just said, I very much appreciate the Q&A sessions. I've noticed that your responses to questions about communication and actions of the board using email do not mention the statute related to actions without meetings. Merely an observation. Well, that's a very good observation from this person. The reason why I don't mention it is there's a very specific reason. And that reason is because there are several administrative law judge opinions in the state of Arizona that state that associations cannot use actions by written consent or actions by unanimous consent to make decisions outside of a board meeting. And so if you're interested in receiving that information, if anybody has any specific questions on that, you're welcome to email me directly at bmulcahy@mulcahylawfirm.com. We have a publication on that, which I'd be happy to share with you. So the bottom line is we do not ever recommend that associations make decisions via unanimous consent or via actions without meetings. The only exception to that is if there's a true emergency. And in those cases, we feel that the emergency provisions in the open meeting law would allow you to do that. In any other circumstances that are not emergency, we really have to look at those 2 administrative law judge cases that pertain directly to associations in Arizona that says that you can't do this. And, that's why I don't include it in my materials. Okay, question 5. Since I'm planning a small claim suit against my HOA and I live in Chandler, and the management company, however, has offices in Gilbert, where should I file? Chandler or Gilbert? Thank you for your help. So you always want to file, my advice to you would be that you always want to file in the city where your property is located. So in this case, you live in Chandler, and your HOA is in Chandler, you should file in the Chandler Justice Court. Next question, number 6. Should the president and association manager give new board members copies or a list of all outstanding violation notices and copies of existing contracts and approved new contracts? Okay, so we have a situation where should this information be shared with new board members by the manager and the president? I guess should or could, or are they required to? Those are all different questions. So if the question is new board members want this information, absolutely, they are entitled to see this information. That's no brainer to me. So if a new board member wants this information, the board should readily and quickly provide it to the new board members. And honestly, they really don't even have to wait the 10 business days under the statute. The board member, this is their responsibility to be aware of these type of things while they're serving on the board. Let's take a little different version of this question, though. Are the president and the manager required as part of like a new training or something to provide this to the new board members? No, they're not required. But if they're wanting more information, they are required to provide it to the new board members. And this question comes up all the time. Why? Because sometimes people who are upset about something, they run for the board, they get elected, and now they're on the board with the people that they served with, that they haven't served with before, that frankly they were kind of upset about. And there's a little bit of a clash on the new board because there's the old guard and then there's the new guard, and the new guard wants all the information. So it is kind of a unique situation, but the old guard needs to share the information. Next question, number 7. Our clubhouse, pool, tennis courts, and exercise facilities are open to residents and guests, but not to the general public. They do not meet the accessibility requirements of the ADA. Is our HOA covered by the ADA? Okay, so great question. We actually have a cheat sheet on this, our federal laws cheat sheet, which I would encourage you to look at. All of our cheat sheets, just so you know, are posted on our website, mulcahylawfirm.com. You just click on the cheat sheet section. And our one on federal laws, complies with this. So is your HOA covered by the ADA? I think what you want meaning to say is, are we required to follow the ADA, which is the Americans with Disabilities Act? So they're not, your pool, tennis courts, exercise facilities are not open to the general public. So keeping that in mind, no, you are not subject to the Americans with Disabilities Act. However, you are subject to the Fair Housing Act. And Arizona has their own Fair Housing Act, and there's also a federal Fair Housing Act. So associations need to be careful not to discriminate against any protected classes. I think probably how this is coming up is maybe the clubhouse, pool, tennis courts, exercise facilities. I guess you're wondering about the accessibility requirements. Like, do they have to have, certain accessible areas in the pool and the tennis courts, et cetera? And so just dialing it back a little bit, they're not subject to ADA, Americans with Disabilities Act requirements, but they would be subject to the Fair Housing Act requirements. And under the Fair Housing Act, we have to allow reasonable accommodations and reasonable modifications for anyone with a handicap. And those modifications or, changes that are requested by the owner, the board needs to look at each one on a case-by-case basis and determine, is there a disability under the Fair Housing Act? And are we required to allow whatever the owner is requesting? And we need to look at those carefully on a case-by-case basis. But remember that, there are reasonable modifications that we may have to allow the owner to make. So for example, If an owner, there's a curb by the mailboxes at your association, and somebody that's handicapped, so clearly a protected class under the Fair Housing Act, wants to get their mail and they can't because of this curb, they could request that the association give them permission to cut the curb and put in a ramp for the handicapped person. It's up to the board if the board wants to pay for this. Under the law, the owner cannot make the board pay for it. This is not ADA community. This is the ADA doesn't apply. So basically, if the owner really wants it and the association refuses to pay for it, the owner, is allowed to have it, whatever the modification is, in this case, the ramp to get to the mailboxes in their wheelchair. But if the association won't pay for it, they'll have to pay for it. So that's kind of an interesting distinction. Really good question. Question 8. We have about $200,000 in a reserve fund invested in CDs. We had a reserve study in 2005 and don't agree on if or when it needs to be updated. What legal issues does this raise, if any? So just kind of as a rule of thumb, you should be having your reserve study updated at least every 5 years. So you're about 16 years, out from your last reserve study. And 11 years ago, you should have done the update on it. So my recommendation would be to get a new reserve company or the same company that you used in 2005 to come out and update your reserve study. And then the board needs to evaluate whether the $200,000 that you have in there right now is sufficient with the updated reserve study numbers. And so what legal issues does this raise? Well, what comes to mind to me is, potential breach of fiduciary responsibilities. Because remember, as a board member, you need to be acting in the best interest of the association at all times. And part of that is that you need to maintain the common areas. You need to follow corporate formalities, and something that is recommended for sure by attorneys that practice in this area and other industry professionals that work in the area of representing HOAs and condos. Having a reserve study done, number one, and then having it updated every 5 years is something that is industry standard, and they should be doing that. It's not the law yet in Arizona, but I think in the coming years, we will see that to be the law. So it would be a best practices type thing. And it's not that expensive. It's really something that your association should be doing. Next question, number 9. Is it permitted to use community resources, i.e. operating the reserve funds, to build a private facility for use by a subset of members? For example, construct a marina in a lake community for use by selected members who pay to lease the slips. I can think of another one, like pickleball courts, right? That seems to be a hot topic. Also, does such situation create a change of use under most governing documents? What is the HOA industry convention for defining a member in good standing? Okay, so we got all kinds of questions here. So is it permitted to use community resources to build a facility for use by a subset of members? Okay, so first you need to look at what do your documents say about association funds. My feeling would be that yes, this would be an allowable use, but I would double check your documents to make sure that's okay. Is it a change of use? It really just depends. How was the land being used before? If it's still a marina, maybe it was a marina before, and now you're just updating it. Maybe you're just building the docks or the slips or whatever, and you never had those before. I'd have to look at the exact language of the change of use in your documents. So under most governing documents, any change to how the property is being used could require a vote of the membership. So it's likely that that is what's going to happen here. How do we define a member in good standing under industry convention? There is no industry standard for this. The standard is what your documents say. So look at your bylaws and your CC&Rs. They will indicate who's in good standing and who can vote at annual meetings of the membership and special meetings of the membership. If I were to give you like a typically an owner that owes any money in unpaid assessments or any money in any other charges to the association, such as fines, late fees, attorney's fees, they would not be in good standing. That's my experience. But again, look at your own documents. Question 10. An owner has a dog that barks for long periods of time, disturbing other owners. Our CC&Rs say that no owner can have a pet that causes a disturbance, makes an unreasonable amount of noise, or becomes a nuisance. How are those phrases generally interpreted, and what kind of evidence should we consider acquiring to substantiate a claim that the dog barking is in violation of the CC&Rs? Okay, good question. We have a cheat sheet on dog barking, just so you know. And again, you can go to our website at mulcahylawfirm.com, click on our cheat sheets section at the top, and then just type in barking dogs. And we give you a lot of suggestions on how to specifically deal with barking dogs. So how do we document this barking dog? Well, I'm sure it's probably a neighbor that's complaining. Ask them to keep a notebook of all the times that the dog is barking and for how long, and the date times, how long the barking, occurred. And then what we would recommend is check in with the city that you live in and see if they have any special programs on this, because some cities have great programs where they have a mediation program for dog barking, or they have code enforcement will come out and enforce it. So check to see if your city can do anything on this. Once you have the evidence, you may want to have your management company send a letter, or your attorney send a letter to the owner. In some cases, the owner may not even know that the dog's barking. So you may want to reach out first with a friendly phone call. And I think that gives you kind of a lot of different suggestions on how to do that. So check out our cheat sheet, which I see was shared in the group chat here. Check with your neighborhood services department to see what the city in your jurisdiction that you live in, what they suggest on dog barking. Reach out to the owner, talk to the owner in a friendly way. If it can't be resolved that way, then go legal. Get your attorney to write a letter to the owner to tell them to stop allowing their dog to bark. And usually what happens, it's just the dogs only, right? They're home, they're waiting for their owner to come back, and they're barking because they think the owner's on the other side of the door. Sad, but so just making the owner aware of that might help the situation a lot. Next question, does Arizona allow for board members to reside out of state or out of country? 2 of our board members fit this description. Meanwhile, it's clear the property is not effectively managed in this situation. Did Arizona pass a ban on smoking on patios or common area in regard to short-term rentals? Thank you. Okay, lots of questions going on there. So, does Arizona law allow for board members to reside out of state or out of country? So what the law says in Arizona is that you can't make it mandatory that board members live on property. So the bottom line on this is anyone who owns a lot or unit in your association likely is able to serve on the board, whether they live in the property, whether they're seasonal renter, whether they don't live in this country, whether they live in a different state, it doesn't matter. Okay, so one way, if you don't like that, because you said you don't think the property is being effectively managed, I think what you need to do is to, run for the board or start communicating with the board that, hey, we're not happy about how this is being handled. You're not here, so here's some pictures so you can see what's going on. And then last but not least, did Arizona pass a ban on smoking on patios or common areas in regard to short-term rentals? There is no ban that pertains to smoking for short-term rentals. Now, of course, your association has the right to pass rules or put provisions in your CC&Rs on that. Okay, next question. We're on question 12 and we have 33 total. Related email sent already. And I actually read this email this morning from this person. And it's talking about the association hasn't had any increases in their dues. And now they don't have an adequate reserve fund. So they've got deferred maintenance that needs to be addressed, and they don't have any money to do it. So the board now is looking to increase their assessments, and a significant increase is needed. So they're challenged, whoever's writing this question doesn't understand the legal calculations for their CC&Rs. And apparently, I clicked on this before I came on this call today and just kind of read it. So this particular owner has a CPI increase, which is the Consumer Price Index, increase in your CC&Rs. So it allows the board to increase up to, whatever the CPI is. And you have to look at the language for each association to determine how that formula is worded. If you disagree with how they've calculated it, what I would recommend is that you go to the board with what your issue is with it, ask them to refer it to their attorney and their CPA and start a dialogue on it, because this is done incorrectly frequently, unfortunately. And you definitely want to raise the issue that this isn't being done properly. And so you said, can I discuss the implications of, using the wrong calculation? Can it be challenged? You bet it can be challenged. And is it ever a nightmare if it is challenged? Because you either have to refund money or you have to ask people for more money if you didn't do it right. It's a procedural nightmare. So your board needs to dial it back a little bit, get advice from the experts as to what this calculation should be and how we should calculate it, and then determine everybody needs to agree. Okay, yes, we all agree. If you don't agree, you can always go to the Department of Real Estate, file a complaint, or file a lawsuit against the association to get them to increase it properly. One other closing point on this one, if your association has a really hard formula to create to get an increase in the assessments, you may want to consider amending that section to take that out, because that makes it really difficult for associations, if it's unclear and then you're just guessing what the interpretation should be for the formula, somebody could question it and it could be a real nightmare to untangle. Okay, next question. In a previous HOA that I was an officer and homeowner, there was a new homeowner fee when someone purchased a single family home in the HOA. We now live in a condo and I'm a board member. Can we charge a new homeowner a fee when they purchase a condo? Or is there a statute for condos that says no? So this is kind of a unique question. So some older sets of CC&Rs have there's a number of different ways to interpret this because I don't know specifically what the homeowner fee is, but it could be like a transfer fee or a capital contribution fee. And if that's the case, you can do that, but you need to amend your documents to allow for you to do that. And we actually have a cheat sheet just on this topic that talks all about the statute and what's required to be placed in the CC&Rs. And it's called transfer fees and disclosure fees. You can go to our website at mulcahylawfirm.com, click on our cheat sheets tab and download the transfer fee cheat sheet. Okay, in regards to 33-1805A, the question surrounds what shall be made reasonably available for examination by any member or any person designated by the member in writing as the member's representative when the member has not owned the property for more than 5 years. In other words, can they request documents over 5, 10, 15 plus years? Is that considered reasonable? So my feeling on it is yes. Just because an owner became an owner recently doesn't mean that they're not entitled to see the corporate history of the association. So I do think that's reasonable, but I also want to just balance that out with, be reasonable in how you word it. If there's something that you really want, maybe pick up the phone and call the manager and ask them, where could I find this? Instead of just going on a wild goose hunt, looking for something and asking for 15 years of records, just making more work for everybody. It'd be better just to pinpoint specifically what information you want and then have the association help you find that document in association's records. Okay, next question, number 15. In 2020, a homeowner filed a complaint with the ADRE regarding methodology for the monthly homeowner assessment implemented in 2020. The administrative law judge found in favor of the association per the CC&Rs and used the word unambiguous. That was a win for the association in the decision. The homeowner is now the board president. He has filed and has been granted a rehearing request. Oh my goodness, what a mess. The attorney for the association that won the judgment has been fired. Is this not a conflict of interest? Okay, I guess I would say it's technically, I don't feel that it's a conflict of interest per se. What it is it's inappropriate. Okay, the homeowner lost, right? And then the Arizona Department of Real Estate issued a ruling saying that this was unambiguous, right? The I don't know if this owner is refiling for a rehearing as the president or as a homeowner. It should be as, a homeowner, in my opinion, and not as the capacity of the president. If he's doing that, any discussion that the board is having on this topic, that board member definitely has a conflict of interest on the discussion of that. That homeowner has the right to do this, ask for a rehearing. I doubt it will be granted. If it is granted, it sounds to me, because it was unambiguous, there's going to have to be like a reversible error here, something that the judge really made a mistake. And it doesn't sound like this is the type of case. So the homeowner who's the president has the right as a homeowner to do this. Okay, that's a legal right that he or she has. They do not have a right to sit in on discussions that the association may have to have regarding, should we tender this to our insurance company? How do we defend it? That homeowner has a conflict of interest on discussing that in any way. And in my experience, those things are not overturned, hardly ever. So question 16, we feel need to increase our dues significantly in order to properly maintain our property. Our CC&Rs, which go back to 1971, only allow the board to raise monthly dues by 3% without 2/3 homeowners' approval. State of Arizona allows 20%. Does state law trump the CC&Rs? Can the board increase the dues 20%? So great question. You've got older CC&Rs, which honestly really do need to be updated. So think about that in the coming year. So it says the board can only increase the dues by 3%. Anything over 3%, you need 2/3 homeowner approval. So I don't know if you're a condo or a planned community. That would be something that would be important for me to know. I'm assuming you're a condo. I'm assuming you're an HOA, because the state law that you're referring to applies to HOAs. But that state law doesn't apply to your association. And here's why. Because that law only applies if your association doesn't have a percentage already listed. And you already do. You have 3%. If the percentage listed was like 25%, then the state law would kick in. So we only go to the state of Arizona law regarding limitations on how much you can increase the assessment when the documents either say nothing about how to increase the assessments, or it allows the board to increase it, over 20% without a vote of the membership. So in this case, the state law does not trump your CC&Rs, because your CC&Rs are specific and the board cannot increase the dues by 20%. Now, again, I'm just going by what you're telling me. So I'd have to look at the documents specifically just to make sure that all the information that you've given me is correct. Next question. An owner did landscaping in a common area without submitting a request for approval. If we approve his request after the fact, what liability is there if we deny other owners a request to do their own landscaping? This could lead to a very unappealing common area look if everybody does what they want. Well, I agree. So owners shouldn't be landscaping the common areas. That's the first thing I'm going to mention. So you really shouldn't be approving it. If you have a majority of your board approving it, by vote, then what you need to do is you need to document it really well. What happened, why the board approved it, who's going to maintain it, what happens if the landscaping dies, who removes it, who replaces it, what happens when this owner moves or loses their property at a trustee sale, if that should happen. All of that needs to be worked out in a written agreement that's recorded on the property so that that owner and any future owner of the property has sufficient notice of what the responsibilities and rights are with this landscaping. And just going forward, I don't think it's a good idea to continue to allow that for new owners. If you do allow it for this one, it's not something that I would recommend for the future. Next question from one of my favorite clients. One of our homeowners rents his property. The lease expires November 1st, 2021. He wants to list his home for sale. If it sells before November 1, does the lease follow the property, or do the renters have to move before the lease expires? I think that's between, the owner and the tenant. It really depends on what the language of the, lease says. So I'd have to see that. Typically, though, when there's a lease in place and there's a buyer that, buys the property while the lease hasn't expired yet, it's still in place. Typically, that tenancy continues on until the end of the lease, and the new buyer knows that they need to honor it unless they can get some sort of an agreement from the tenant to vacate sooner. Next question. In the condominium project, units are owned by individuals and the rest of the real property is owned collectively. Each owner has an undivided interest in the common elements as set forth in the association's documents. When an owner increases the size of his patio or deck, he is increasing his footprint, which then no longer matches the description in the plat. Does that constitute a change to the CC&Rs or of that project? What is the cure for that? So this is kind of a sticky wicket, tricky question because it just depends. Sometimes people, they enclose their deck, right? Or they put windows on their deck, or sometimes they just, add a little pathway. So it really depends. We have to look at this on a case-by-case basis. We'd have to look and see, are they extending into the common areas? If so, has the board approved that? Kind of like along the same lines of the question, 2 questions ago. So does it constitute a change to the CC&Rs of that project? I don't know. I don't know if the board has approved it. If the CC&Rs and the plat map are specific as to the lot lines or the unit lines in this case, and the owner is extending outside of that, it could, be something that is contrary to what your documents state and to what the plat states. You should talk with your legal counsel about it. What is the cure for it? Sometimes it's unintentional. Sometimes they hire a contractor and the contractor goes a foot into the common areas. So you can have a written agreement like we talked about 2 questions ago, or you could maybe make them put it back. Talk to your attorney about that because they'll have some good suggestions on how to fix that. Okay, question 20. We are in the process of changing HOA management companies. Can our current company charge fees that were not in our contract? No, they cannot. So look at the exact language of the contract. Also, mid-year, he started adding online fees to his statements. When we inquired about them, he commented that Arizona law requires them to be on his monthly statements. I had suggested it to be an expense on our profit and loss statement. So I don't know what the online fees were. Maybe it's like a late fee or maybe like a file transfer fee. I don't know. But I'm in agreement with you that the fees shouldn't be on, they shouldn't be charging fees that aren't part of the contract. Now, there's some exceptions to that because there may be, fines or something that are levied or late fees that may not be addressed specifically under the contract, but associations have the right to charge those under state law. But who gets those fees, which bucket those go into, the association or the management company, all of that should be outlined in the contract. So I hope that answers your question. Are political banners allowed to fly in a carport anytime or just before and a short time after the election? So it really depends on what your associations, want to allow and not allow. So we already talked about the state law at the beginning of this presentation that allows an owner to have, political banners or flags or signs before, an election. And then it's now going to probably be extended out after the election if the governor, once the legislative sessions ends and the governor's already signed that bill. So most association documents don't allow this. If I had to, guess, I don't know what your documents state. So if it doesn't allow it and we're not in the time period, in that window before and after the election, the association can prohibit it. Next question, number 23, short-term rental rules in our CC&Rs. We have a rule that limits STR to a minimum of 30 days, short-term rentals, which I would interpret to mean no more than 12 per year. I have heard an HOA is considering changing their short-term rental rules to a minimum of 30 days, but no more than 6 per year. Does the state or Chandler limit short-term rentals in any way beyond what an HOA may have in their CC&Rs? So the state and Chandler do not limit short-term rentals in any other way because there was a law passed in 2016 that prohibits them from doing that. So whatever's in your documents, that is going to be what controls pertaining to short-term rentals. When an HOA board does not meet quorum at an annual meeting, is it appropriate to immediately adjourn and go into an open session as a way to handle business? So great questions. So if you don't have a quorum at the annual meeting, that means that there's no official annual meeting, and you should renotice the meeting and try to conduct it again in a reasonable period of time. It probably is outlined in your bylaws. It usually tells you. Can you go into, just kind of an open session? You came anyways, so let's talk association issues. You can, but that may make it difficult to get a quorum at the reschedule of the meeting because people have already heard everything. And it's also not an official annual meeting, and so you don't want to characterize it as that. So you shouldn't be counting, ballots for the election of the directors, etc. But you could use it as a way to communicate with owners. Okay, another one of my favorite clients asks, during the recent past, many organizations have been using the Zoom platform to conduct HOA meetings. One of the nagging issues that may need clarification is providing agendas, minutes, and financial statements to the community participants, so people who are not board members, who are owners in your community. Should they be made available prior to the actual meeting in PDF format for downloading, or should they be shown on the screen during the actual meeting presentation? What recommendation can the Mulcahy Law Firm provide? Okay, so really good question. My recommendation is give people as many of the documents before, during, and after the meeting so that anybody who wants to see it can see it. So before, you could put it on your website in a password protected area. You could post it on the agenda, somewhere if it's short enough. You could add it as an additional sheet, when you post the agenda and the notice. Afterwards, you can put it on the website. I just think my recommendation is do what your homeowners are requesting. If you have people that want to see it before and want to have it emailed to them, give it to them. If you have people that want to see it afterwards, put it on your website. Just make it easy for people and show how transparent you are. Agendas, minutes, and financial statements are not anything that is protected, and we should be giving those to the members as they request. Who is qualified to write the reserve study? How do you prevent the current board of directors from abusing their position by emphasizing their current pet projects and more or less ignoring the long-term ones when the reserve study is being updated? Okay, so who's qualified to write the reserve study? There is a special designation through the Community Associations Institute for reserve specialists. So in my opinion, someone qualified to write the reserve study would be somebody who's a certified specialist in reserve studies. How do you prevent the board from abusing their position by doing their pet projects instead of long-term ones? Go to meetings, document it in the minutes, make comments at the meeting, ask them to put in the minutes, write letters stating that you disagree with how the board is handling, the projects that they're working on, and run for the board if you don't like how the board is running things, and then turn it around and do it the way you think it should be run. Or remove the board. There's a whole procedure to remove the board of directors if you're unhappy with how things are going. And it's very difficult to do that. There's a many-step process. Okay, a few owners in our condo community want to have a part of a common area to use for a feral cat feeding area. Do we need homeowner approval? Okay, so I guess the question is this a good idea? Would be the question I'm going to interject. I don't think this is a good idea. I don't think that you should have the association sponsoring a feral cat feeding area. That's just my opinion. Would you need homeowner approval if you're changing the use to have this type of an area on your common areas? It really depends on what your CC&Rs say. It could be considered a change of use. It's kind of like a dog run. Now this would be a feral cat feeding area. It just depends on how large it's going to be and how many cats you have. But really, again, I'm just going to state for the record, I don't think that's a good idea. Next question. What does a POA do for homeowners? We have a homeowner who sent in a power of attorney and the property manager says it's worthless. Is this true? Well, probably yes. So the crazy thing about a power of attorney is it's a legal document that, like, I give my power of attorney to so-and-so. And it's a legal document that would allow so-and-so to sell your house, which is kind of crazy, right? Give a power of attorney to somebody to sell your house. But the power of attorney doesn't give a homeowner the right to transfer their ability to vote on association issues via power of attorney. So your property manager saying it's worthless, it is true. A power of attorney does not work in the association meeting context or in the association voting context. If you want somebody to go to the meeting for you and handle things on your behalf, you would just make them your designated agent and they can talk on your behalf, but they still can't vote. Next question. Prior board was never voted in. Changed items in the CC&Rs, such as paint colors and allowing people to park on gravel and RV campers. Neighbors now say that items were approved by the board and not wanting to change the violations. What should we do as an official board now? If you don't like the policies, your board should reverse them. And I don't know, it says never voted in, changed items in the CC&R. So apparently the CC&Rs are recorded without, those changes being approved, it sounds like. It just depends on where you are in this process. It's 6 years to challenge a CC&R amendment if you're a planned community, which I'm guessing that you are, because paint colors usually in a homeowners association, the paint colors are an issue because the homeowners are repainting. Condo, the association repaints. So what should we do as an official board? Reverse them and do it the right way. You may have to amend the CC&Rs, by getting a vote. You may be able to do it by a affidavit of correction or notice of errata. It just depends. Bring it to your attorney and have them help you, and they'll help you figure that out. Okay, last few questions. Question 30, can an HOA vote for no rentals within an HOA? If yes, how would the landlords have to act? Sell their homes? We have a great cheat sheet on this subject, and it's called Implementing Rental Restrictions, and it's part of our cheat sheet on amending association documents. So I would encourage you to look at that. You can find that on our website at mulcahylawfirm.com. So the bottom line is, can an HOA vote for no rentals within an HOA? Answer to that question is possibly yes. We got to look at what your documents say right now and confirm that you're actually an HOA. But how do we deal with the landlords, maybe who have current leases? Well, you may want to grandfather them. And we talk about this extensively in our cheat sheet. So I would encourage you to look at that. Tell them to sell their homes. That's probably going to be a bad idea, and it's probably going to result in a lawsuit. So I would try to find a win-win. Maybe you grandfather the existing landlords that are opting on this for a time period or for as long as they own it. You just have to strategize with your attorney as to what's the best way to do it. But definitely check out our cheat sheet on this because it's a really good one. Again, that can be found on mulcahylawfirm.com. And it's the Amending Association Documents and Implementing Rental Restrictions cheat sheet. Okay, last 3 questions. A member disagrees with the board decision on their appeal. Now the member is going to each board member's home because the member is convinced the board doesn't understand their side of the story. Is this appropriate behavior? No. If not, how do you recommend the board address this with the member? I would send them a cease and desist letter. I would have the attorney send them a cease and desist letter saying, this issue's been decided. There was an appeal. The appeal has been decided. Please do not go to the other board members' homes. If you have a problem, you're welcome to come and talk during the homeowner forum of a board meeting. But, this is inappropriate behavior and you need to cease and desist from doing that. Next question, last 2. What are the steps necessary to modify? Oops, I guess I have a few more that's been added. A lot more that have been added. I didn't see that. Sorry about that. I thought 33. Okay, so the next question, maybe how many do we have total? Just so I keep everybody about 41. So we have about 9 more questions. Okay, so let's see, where am I here? Okay, question 31. A member disagrees with the board. Oops, sorry about that. Okay, next question. What are the steps necessary to modify and update our CC&Rs? Okay, I just talked about that. We have a great cheat sheet called Amending CC&Rs 5-Step Plan. I just saw that Yvonne from my office shared that in the chat, so take a look at that. You can find that on our website too at mulcahylawfirm.com, and it will give you all the steps. There's a 5-step plan that we have. We also have a great video on that if you go to our YouTube channel. And it'll give you just a quick 5-minute answer on that. That will help you a lot. Next question. Under ARS 33-1254, can an HOA automatically or legally roll over any surplus monies into the reserve fund for capital expenditures? Or can they deposit a percentage of the overage and refund the homeowners the balance? There's nothing stated in the CC&Rs or bylaws. So can we automatically roll over a surplus in your budget? Talk to your CPA about this. I've had this issue come up before, and sometimes you are able to do that and sometimes you aren't. So I would say go to your CPA on this and see what their position is. If previous residents can't be located to give them a water rebate after a certain amount of time, is there a requirement to transfer funds to an unclaimed funds entity, or can the HOA retain the funds? So I'm not exactly sure how you're setting up like the water rebate for your association, but I'd have to look at the documentation on how that was set up. But I don't believe that you'd have to transfer funds to an unclaimed funds entity through the state. Likely the association would be able to retain the funds. Okay, so we'll do a couple of these questions. Some people have asked a second question. And so we just have a very few of those. Just looks like 1, 2, 3, 4, 5. And so I'll do those really quickly. Okay, another question from one of my favorite clients. This week in the news, there's an HOA that is demanding a 92-year-old veteran to remove a bench from the front of his property. This bench has been there for 10 years, and the HOA took no earlier action. Does the HOA still have a right to enforce something they have taken no past action on? So short answer on that is this is a bad idea all around. I mean, who does that to a 92-year-old veteran? I think that's a very bad move by that association. Number one, just from being human and caring about people, I think that's a little bit excessive. I'd have to see, more about the bench and what the rules say, but it seems a little bit over the top to me. Also, it's been there for 10 years. The association is precluded from enforcing that under waiver and latches. Next question. What happens if the HOA is using a lawyer and the HOA lawyer, not the property manager, asked any of the board members to use the HOA lawyer? I'm not sure what the person's saying. Okay, so what happens if the HOA is using a lawyer and the HOA lawyer nor property manager asked any of the board members to use the HOA lawyer? Oh, okay, I get it. So you're saying this is maybe a holdover HOA lawyer, or maybe, somebody that, I don't know if the HOA lawyer is billing for stuff and nobody's asked for it, or what's going on here. But really, the association board makes the decision who the lawyer is for the association. And if no one has hired this law firm, you should send them a letter saying, please don't do any more work for us. Okay, next question. Is the area between a common wall adjacent to a public right-of-way and the sidewalk considered a common area? An owner wants the board to demand the owner of the property with the common wall to plant landscaping in that area. So really, I can't answer that question without seeing your plat map and your CC&Rs to determine if that is a common area. So you'll have to look at that and determine whether or not you can make them landscape that area. Next question, 3 more. What are the requirements to increase the size of the board from 5, as noted in the CC&Rs, to 7? Can the board do this, or does it require a vote of the owners? It really just depends on how it's worded. Some documents say you can have as few as 3 board members up to 7. And in that case, typically the board can, move from 3 to 5 to 7. It's always a good idea to make it an odd number so that, tie votes can be, make a decision on tie votes. But if it just says like a number certain, like 5-member board, and you want to change it to 7, then you would have to amend the CC&Rs if it's specific in your CC&Rs that way. Last 2 questions. In our association, the owners own the plat of land their home sits on, but the yards are maintained by the association. If a worker should get hurt on my property, can the owner be liable, or is the association as the contracted property? Well, I think both sides can be liable. It's just going to depend on how the person got hurt. Was there some sort of a defect in the property? How did they get hurt? Was there a pothole that the owner, should have fixed? what I will say based on my experience is that in those cases, everybody gets named. Sorry. And then the parties just have to figure out liability after the lawsuit in terms of who was at fault for this. Okay, last question. We are still under declarant control. What responsibilities does the declarant have after the residents form their own HOA board? Large community of 3,000 homes. So great question. So look at our cheat sheet. We have a cheat sheet on transition from developer to owner control. I think that would be a really good resource for you, and you can find that on our website at mulcahylawfirm.com. And so what responsibilities do they have once the HOA board is in place? It really depends on what your documents state. Lots of times the HOA board doesn't go into place until there's been a transfer of power between the board and between the declarant and the board. Usually that occurs once 75% of the lots are sold or 67% of the lots are sold. Sometimes it doesn't happen until the declarant sells the very last lot that they own or last unit that they own. So really you have to look at your documents to see that. In our cheat sheet, which we're going to be sharing with you, or you can find on our website at mulcahylawfirm.com. And again, that's a cheat sheet on transition from developer to homeowner control. We list the most common problems that occur at this transition time. So what responsibilities does the declarant have? They should leave the common areas in good condition. They should adequately fund the reserve at the time that they leave. There should be plenty of money in the general checking accounts. The budget for the association should be right on. It shouldn't be a shortfall of money for the new board when they take over. Those are just kind of some of the main things that we would suggest, but also look at our cheat sheet to make sure that we've covered everything. There shouldn't be any defects in the common areas. I mean, there's a number of issues that can come up when there's a transition, but check that cheat sheet. It'll give you a good checklist of things you should be looking for. Getting your documents back is another thing that comes to mind. Okay, we got through 41 questions in 1 hour, 9 minutes. Great job, team. Just some concluding remarks as we finish out our 6th class. Thank you again for joining us today for our 6th class of the Spring 2021 HOA Condo Virtual Academy. Thank you for being here today. Thank you for caring about your communities and trying to make them better. I'd like to take this time to thank the neighborhood services departments from the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, and Tempe for being great team members and working with us as a partnership to put together these amazing virtual classes. Just a reminder that due to the 4th of July holiday, we're going to be skipping our first Friday free call-in, free virtual call-in in July, and we'll be resuming that again in August. Our next First Friday live Q&A session will take place on Friday, August 6th. And we're finalizing our class schedule for the last 6 months of 2021. And we're going to be putting that online very shortly. So check out our website at mulcahylawfirm.com for a full listing of our future classes. We should have those posted by close of business today. And for those of you who are on our mailing list, if you're not, you should be, because it tells you about all kinds of great information pertaining to HOA and condo law. We'll also be sending out a full listing of the classes for July through December. We're going to be doing them again in a virtual format. And we used all your feedback from the wonderful survey that many of you filled out for us. And we've created 6 amazing classes on different content that will help your association. So we hope you'll join us in the second half of 2021 for those 6 virtual classes. Thanks again for being here today. I hope everybody has a great 4th of July that's coming up here soon. Take care of yourself, and I hope you continue to serve your communities and help your communities the way you are. So thank you for being here today. Take care, everybody. Bye.